Wayfarer Studios, which is the studio that was co-founded and co-owned by Justin Baldoni and Steve Sarowitz, has responded in New York State Court to the New York Times anti-SLAPP suit against them. The New York Times was named in Justin Baldoni and Wayfarer's countersuit against Blake Lively and others, but they've been dismissed from that case since the judge made the initial ruling in June. So the Times is now asking that Wayfarer pay their legal fees, costs, and disbursements.
The New York Times wants $150,000. Their target? Justin Baldoni's production company, Wayfarer Studios. And they're claiming this entire legal battle was nothing more than harassment designed to silence the press. But here's the twist nobody saw coming. Wayfarer just filed their response, and they're not backing down. In fact, they're accusing the Times of the very thing Blake Lively's been doing to content creators for months, using the legal system as a weapon. Could this backfire on one of the most powerful media organizations in the world? Or is Wayfarer fighting a battle they can't win? Before we dive in, make sure you're subscribed and hit that notification bell. This case is moving fast, and you don't want to miss the next bombshell. Drop a comment below and let us know whose side you're on. Now, let's break this down. The New York Times filed an anti-SLAPP motion in New York State Court against Wayfarer Studios. For those unfamiliar, SLAPP stands for Strategic Lawsuit Against Public Participation. Essentially, it's when someone files a lawsuit not to win in court, but to intimidate, harass, or silence someone from speaking out. New York has a law specifically designed to protect against this. And now the Times is invoking it, demanding that Wayfarer pay all their legal fees, costs, and expenses for what they claim was a baseless defamation case.
We went over the Times complaints back in September when this first came out, and I was going to go over Wayfarer's response in a live stream, but then I realized the answer is actually very short. It's like 6 pages, and there's not a whole lot of substance to it. It's just denying or admitting things paragraph by paragraph, like we saw in their answers to Blake Lively's lawsuit.
Here's where it gets interesting. The Times was originally named in Wayfarer and Justin Baldoni's countersuit against Blake Lively and others. But back in June, the judge dismissed the Times from that case, ruling they were protected by journalistic privilege. The reasoning? Blake Lively had filed a complaint with the California Civil Rights Department. And when the Times reported on that complaint, they were simply doing their job as journalists covering a legal filing. So technically, the Times couldn't be sued for defamation because they were reporting on something that was part of the public record. But does that mean they acted responsibly? Wayfarer doesn't think so. And neither do a lot of people who've been following this case closely. The Times is now asking Wayfarer to foot the bill for their legal defense, claiming the lawsuit lacked any substantial basis in fact or law. They've racked up at least $150,000 in fees. And under New York's anti-SLAPP statute, they can also pursue punitive damages if they prove Wayfarer filed the suit solely to harass or intimidate them. Sound familiar? It should, because that's exactly what dozens of content creators are dealing with right now thanks to Blake Lively's subpoena campaign. Independent journalists, YouTubers, podcasters, people with far fewer resources than the New York Times, are being dragged into depositions and forced to hand over private communications. The irony is almost too much. Wayfarer's response to the Times complaint is short, just 6 pages. Most of it follows a standard legal format, denying allegations paragraph by paragraph, admitting only the undisputed facts, and referring the court back to previous filings. But there are a few key points worth highlighting. In paragraph 14, Wayfarer admits the lawsuit was filed on January 16th, that it was later consolidated with Blake Lively's case, and that the Times wasn't originally named as a party. People forget this detail. Wayfarer initially tried to sue the Times in California, but the Times was never actually served with that complaint. Eventually, they were brought into the New York lawsuit instead. The most significant pushback comes in paragraph 22. The Times had argued that the judge's ruling made it clear their reporting had full legal protection and that Wayfarer's claims were baseless. But Wayfarer's response is firm. The judge never said their claims lacked merit. The issue was privilege. The Times was protected because they were reporting on a legal complaint. That doesn't mean what they reported was accurate. It doesn't mean they did proper due diligence. It just means they couldn't be sued for it. And here's the thing. Privilege is a double-edged sword. When someone files a legal document, they can make all kinds of accusations, and they're shielded from defamation claims because it's part of the court process. The same goes for journalists reporting on those filings, but that privilege can be abused. Some people use the courts specifically because they know it gives them cover to say things they could never say publicly without facing consequences. They weaponize legal filings to plant narratives in the press, knowing reporters will run with it. Did that happen here? A lot of people believe it did. Blake Lively filed her complaint with the California Civil Rights Department. The New York Times ran with the story, and suddenly, Justin Baldoni was painted as a predator in the court of public opinion before any of the facts were tested in an actual courtroom. Wayfarer's defense hinges on this argument. Their lawsuit wasn't a SLAPP because it was based on legitimate grievances about how the Times handled the story. In paragraph 32, Wayfarer explicitly denies that the lawsuit was filed to harass, intimidate, or punish anyone. They argue it wasn't about silencing the press. It was about holding the press accountable for what they believe was irresponsible reporting. Whether that argument holds up in court is another question entirely. But the bigger issue here is what this reveals about how the system works. The New York Times has the resources to fight back. They have an army of lawyers. They can weather a legal battle and come out the other side demanding reimbursement. What about the independent content creators being hit with subpoenas right now? What about the crew members who worked on the set of It Ends With Us and are too scared to speak publicly because they fear retaliation from Blake Lively and Ryan Reynolds? That's the real story here. And it's one the Times conveniently left out when they rushed to crown Blake Lively as the next face of the Me Too movement. Let's rewind for a second and talk about how we got here. This entire saga started with the production of It Ends With Us, the film adaptation of Colleen Hoover's best-selling novel. Blake Lively starred in and produced the film. Justin Baldoni directed it and co-starred alongside her. His production company, Wayfarer Studios, co-owned with Steve Sarowitz, was behind the project. Somewhere along the way, things went south. Blake Lively filed a complaint alleging sexual harassment and a hostile work environment on set. She also accused Baldoni and his team of orchestrating a smear campaign against her online, hiring crisis PR firms to manipulate public perception and damage her reputation. Baldoni denied everything. His legal team fired back with their own lawsuit, alleging that Lively had actually taken control of the film's production, sidelined Baldoni creatively, and then weaponized false accusations when things didn't go her way. The New York Times entered the picture when they published a story based largely on Lively's complaint. The article painted Baldoni as the aggressor and Lively as the victim. It became a massive story overnight, but here's what didn't make it into that story: the other side. The text messages. The on-set videos. The statements from crew members who say the narrative being pushed doesn't match what they witnessed. Wayfarer and Baldoni's legal team argue the Times failed to do proper due diligence. They claim the paper didn't give Baldoni a fair chance to respond to the allegations and didn't investigate whether Lively's version of events was accurate. Instead, the Times ran with the story, and the damage was done. Baldoni's team then tried to sue the Times for defamation, but the judge ruled the paper was protected under journalistic privilege because they were reporting on a legal filing. That brings us to today. The Times wants Wayfarer to pay their legal bills. Wayfarer is saying no. This wasn't a frivolous lawsuit, and the Times shouldn't be able to hide behind privilege when they failed to act responsibly. What does New York's anti-SLAPP law actually say? In simple terms, it's designed to protect people from lawsuits that are filed just to shut them up. If someone sues you in an attempt to silence your free speech, and the case is baseless, you can fight back. You can recover your legal fees. And in some cases, you can even win compensatory and punitive damages. The key phrase here is, without a substantial basis in fact or law. That's what the Times has to prove. They need to convince the court that Wayfarer's lawsuit had no legitimate legal foundation, that it was purely an attempt to intimidate the press and drain their resources. But Wayfarer is arguing the opposite. They're saying their lawsuit was based on real concerns about defamation and irresponsible journalism. And they're using a series of affirmative defenses to push back. Some of these defenses are standard legal maneuvers. For example, they claim the Times complaint fails to state a valid cause of action, meaning it doesn't meet the legal requirements to even move forward. Others are more technical. They invoke doctrines like waiver, estoppel, unjust enrichment, and unclean hands. These are legal principles that essentially argue the Times isn't entitled to relief because of their own conduct or failure to act properly. One defense stands out: the First Amendment. Wayfarer is arguing that their lawsuit is protected speech under the First Amendment. They're saying they had a right to challenge what they believed was false and damaging reporting. And if that's true, then the Times can't turn around and claim the lawsuit itself was an attack on free speech. It's a bold strategy. And it's not without risk. If Wayfarer loses this fight, they'll be on the hook for the Times' legal fees. And that's just the beginning. The Times could also pursue damages, which could push the total cost significantly higher. But if Wayfair wins, or even if they manage to create enough doubt about whether the lawsuit was truly baseless, it sends a different message. It says that journalists can't just hide behind privilege when they publish one-sided stories without doing proper investigation, and that's a conversation worth having. Because right now, we're seeing what happens when powerful people use the legal system to silence critics. Blake Lively isn't going after the New York Times. She's going after independent creators, YouTubers, podcasters, people who don't have teams of lawyers to defend them. One of those people is Andy from Popcorn Planet. Just recently, a Florida judge ruled against Andy's motion to quash Blake Lively's subpoena. The judge said Andy doesn't qualify for journalistic privilege because he's not a salaried employee of a traditional news organization. He's an independent YouTuber. That ruling is troubling for a lot of reasons. It suggests that only people working for established media companies deserve protection. Everyone else? Fair game. Andy interviewed crew members from the set of It Ends With Us for a documentary. Some of those crew members spoke on the condition of anonymity because they were afraid of retaliation. Now Blake Lively's legal team wants Andy to hand over all his communications and reveal his sources. If that happens, it sets a dangerous precedent. It tells independent journalists they can't protect their sources. It tells whistleblowers they can't speak out without risking exposure. And it completely undermines the entire point of a free press. This case is about more than just Justin Baldoni and the New York Times. It's about who gets to control the narrative. It's about whether powerful people can weaponize the legal system to intimidate anyone who questions them. Blake Lively filed a complaint. The Times ran with it. Justin Baldoni's reputation was destroyed overnight. And now, when he tries to fight back, he's accused of harassment. Meanwhile, independent creators who dare to cover the story are being subpoenaed, dragged into depositions, and forced to spend money they don't have on legal defense. Where's the outrage about that? The Times is asking for $150,000 because they had to defend themselves in court. But what about the YouTubers who are facing the same thing, without the backing of a billion-dollar media corporation? If this case moves forward and Wayfair is forced to pay, it sends a chilling message. It tells anyone thinking about challenging a major media outlet, don't bother. They'll bury you in legal fees and then make you pay for the privilege. But if Wayfair holds their ground, if they can show their lawsuit wasn't baseless, it could shift the conversation. It could force people to ask harder questions about how stories like this get reported in the first place. What do you think? Was Wayfair's lawsuit legitimate, or was it just an attempt to silence the press? Should independent creators like Andy from Popcorn Planet have the same protections as traditional journalists? Drop your thoughts in the comments below. And if this case has taught us anything, it's that the fight for truth doesn't end when the headlines fade. It's just getting started. Make sure you're subscribed so you don't miss the next update. This story is far from over.